Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, without any further ado, it's my pleasure to introduce our panel. Just going alphabetically here, I'm going to start with Joan Cochran. Joan is a veteran civil litigator with over 35 years representing insurers in complex coverage, bad faith, regulatory, and contract matters across nearly every major insurance sector. She frequently lectures on insurance law, trains claims professionals, and is recognized as a super lawyer for her expertise. Joan brings deep industry knowledge and practical insight into insurance disputes. Thanks for being here, Joan. Next, we have Tanya Gomerman. Tanya is an award-winning plaintiff's attorney and founder of Gomerman Bourne & Associates. She's secured multiple 7-figure results in employment and personal injury cases and has been named a Super Lawyer Rising Star for 8 consecutive years. Known for her tenacity and client-focused approach, Tanya litigates at every stage from negotiation through trial and appeal. Thank you for joining us today, Tanya. Our next speaker is Judge Avilio Grillo. Judge Grillo served more than 20 years on the Alameda County Superior Court, most recently in the Complex Trial Department, where he handled class actions, mass torts, and insurance coverage matters. Twice named Trial Judge of the Year by the ACCTLA, Alameda Contra Costa County Trial Lawyers. He authored over 50 published appellate decisions and chaired the court's ADR committee. Now with ADR Services, Inc., he brings deep expertise to mediating and arbitrating complex civil disputes. Thank you, Judge Grillo, and thank you for moderating today as well. Our next speaker is Judge Paul Herbert. Judge Herbert brings over 40 years of civil litigation and judicial experience, including service as an Alameda County Superior Court settlement judge, handling all types of civil matters. Formal trial and appellate attorney, he's known for his fairness, his preparation, and practical approach to resolution. He now serves as a mediator, arbitrator, and referee here at ADR Services, Inc. as well. Thanks for being here, Judge Herbert. And finally, we have Mike Lawrenson. Mike is a seasoned trial lawyer and leader of the Gordon Reese Northern California Trial Practice Group and a BOTA member. He has twice been named one of California's top labor and employment attorneys and has earned multiple top defense verdict honors. With over 25 years defending employers in discrimination, retaliation, and wrongful termination cases, Mike is known for his strategic and trial-ready approach. Thanks so much, Mike. So our star-studded panel here ready to take us away. I will bring up our agenda here for Judge Grillo to take it over and introduce our program.
Okay, thank you very much, Katie. First of all, I'd like to thank all our panelists who've come together to put this program together, and I'd like to thank everyone who is here as an observer or participant. The genesis of this panel was some discussions that some of our mediators, including myself and Judge Herbert at ADR Services, had, where we were discussing how much insurance drives what you can do in settlement and mediation, and how many subtleties there were that would actually shape what a settlement ultimately looked like. The more we talked about it, the more we thought there ought to be a program on this to talk about it, and we didn't see one. So we said, well, okay, we'll do one. I think it's fair to say we'd like to think of this as the first in a series of these types of programs because we think it brings a lot of value to the practice. So here we are. Now, I'm going to cover very briefly what we're going to be doing today, and then I'm going to be turning this over to our panelists. Can we go to slide 2? There it is. We're going to be covering insurance fundamentals. We'll talk a little bit about the types of policies that are in litigation, some key coverage concepts, carrier considerations, and that's really important. We're going to talk very briefly about some new changes in the law regarding policy limit demands, and then the discussion and the educational process is going to switch to some hypotheticals where we are going to be asking you some questions. We're going to be wanting to get your feedback, and then we will have a discussion after we receive the feedback. And then towards the end, we're going to have some non-polling discussions where the panelists will be talking about particular problems, and these will be actual problems that they've seen, and to be able to discuss with you some of the subtleties they encountered while they were either participating as an attorney in the case or as a mediator. Um, One last thing I want to mention, you have a glossary as a glossary of insurance terms as part of your program materials. The glossary is not gospel. What it represents is a number of us looking at what some of these terms were. Some of them were lifted out of insurance policies, and they seem to be pretty common in several different types of insurance policies. Or we looked at other definitions of those terms and we put them together in something that we think represents kind of what's out there. There is no firm, hard glossary of terms. You have to look to the policies. And with that introduction, I'm going to turn us over to Judge Paul Herbert, who will be talking about not only insurance as a resource in litigation, but also the importance of policies and different types of coverage. Paul?
Thank you so much, Avilio. My role now is basically to provide an overview uh, that then will provide context for the rest of our discussion. Um, of course, we don't know, we presume everybody has some familiarity with the area, but we don't know the different levels of familiarity that the different folks have who are attending today's process. Uh, uh, I'll just start by indicating that in my experience, insurance is, a key resource for everyone to a dispute. Uh, for plaintiffs, of course, it's the most direct path to compensation because the assets are there and available. They've been reserved by the carrier, etc. Um, for defendants, it provides them with a defense. We all know how crushing legal expenses can be if you're having to pay the attorney yourself, and as well as indemnity against catastrophic loss. You'll see, of course, there are different types of policies that we'll discuss in a little bit, where in many instances the insured shares in the burden with the carrier at certain levels and so forth. And we'll talk about that. And then, of course, it's also important to lien holders. There are folks that have been making payments along the way as the litigation has kept going, whether it be healthcare providers, insurance companies who are providing medical coverage for folks and so forth, workers' comp carriers who are providing workers' comp benefits when a loss has been caused by perhaps by a third party, etc., and so on and so forth. It's a key resource for lien holders, and all of these folks need to be thought about and taken into consideration as you prepare your case, but also, for the mediation or the settlement conference that's gonna occur down the road. Today, our focus is on third-party insurance coverage disputes. We're not dealing at all with first-party stuff. Uh, that's for a different day and a different seminar, but it's just really having to do with third-party disputes in various topic areas. Uh, so it's my belief that attorneys need to understand insurance, and all the attorneys on all sides need to have really a good grounding in insurance, as does the neutral, the mediator, for example, if we're gonna ultimately get this to a mediation or a settlement conference. Um, Understanding the insurance is going to impact your strategy in the case, how you plead the case, how you discover the case. So, it's important for you to have basic familiarity with the insurance concept so you know what to ask for and you know kind of what resources to marshal. Um, Policies are sort of the quintessential, they giveth with one hand and they taketh away with the other hand. So you really need to understand most insurers have no clue about what insurance does and how it works and why it only covers certain things. But everybody needs to understand, lawyers need to understand that it has various limitations in terms of what it will do for you, both for defense and indemnity, honestly. Um, and it has various parts that are, go back to that one before, Katie. It has various parts that are important. There's the coverage problem. Most folks understand, gee, I got to make sure I read the exclusions because exclusions that's pretty obvious. They're going to take away coverage. But honestly, super important for everyone to provide focus initially to the coverage promise or the coverage grant um, portion of the policy. It's the thing that giveth, and it also affects the burden of proof. It's the insured who has the burden to prove that a particular loss comes within the coverage promise, not the insurance company. So the insured has to make sure that if they're going to tender a claim to their carrier, that it actually triggers the coverage promise portion of the policy. Um, and then, of course, it's the carrier's responsibility and their burden of proof to show that an exclusion applies to a particular loss. So I would just say, understanding the coverage positions is going to allow the attorneys on both sides to better advise their clients about their particular types of risk that they're going to face in the lawsuit, and also the particular types of recovery that might be available. Um, and lastly, it's your understanding of insurance, I think, is really important for you. It's essential for you to be able to adequately prepare your client, whether it be a plaintiff or defendant, um, for both hopefully a mediated settlement or a settlement of some kind, and or for trial. I think I found in my own mediations and settlement conferences that lots of times the insureds themselves have really very little understanding of what limitations there might be that they're going to get stuck with in terms of bills if the case were to proceed to trial and a verdict were to be rendered against them. Okay, let's move on to the next slide. So the first thing you've got to do, of course, is assess whether the allegations in the complaint fall within the insuring clause. Um, and I've quoted here sort of a typical one. This is a basic one. The insurer, quote, agrees it will pay those sums the insured becomes legally obligated to pay as damages because of bodily injury or property damage caused by an occurrence during the policy period. Each one of those terms that's in quotation marks is a defined term, and you're going to have to consult the definitions portion of the policy. To really understand what it is they're promising to do. And these things vary from carrier to carrier and policy to policy. Now, there are some standard forms that often carriers use, but trust me, depending upon the topic area and the type of loss, there are nuances associated with each of these definitions and so forth. And so you really need to get the policy itself. And that's both if you're plaintiff's counsel or defense counsel. You need to get the copy of the policy to really understand what it's going to cover. My typical practice is once I get the policy, I actually copy the definition of the term and paste it into the coverage promise. So now I'm going to get a longer paragraph that actually has all the verbiage that I need to fully understand to understand whether or not the coverage promise is triggered. And then assuming that you get past the coverage promise, super important. Why? Because obviously, if you're an insured, you want to be defended. And if you can't get past the coverage promise, you're not going to get a defense. The carrier may deny the claim outright. If you get past that, then you have to, of course, focus on the exclusions. And the exclusions have many different nuances. Again, you can't assume anything. You really have to get the policy itself to understand precisely what particular wording was used in their particular exclusion, and then look for cases that interpret that particular wording. Okay,
Real quick, Paul, how can pleading affect coverage?
well, if if you plead the case with only intentional torts, for example, let's say it's a teacher who is accused of assaulting a student, roughing them up or something, or taking away their their phone or something else. Um, you have to if all the plaintiff's lawyer does is allege intentional torts, they're not really doing themselves or their client a favor because the um, the carrier may not have an obligation to defend that type of claim. So instead, what you'll see, the experienced plaintiff's counsel will include a claim for negligent hiring and all just straight negligence, all sorts of other claims that might potentially trigger the coverage promise. All right, so let me move on to the next slide. So let's talk about, so we see some common issues that come up depending on case type. And I wanted to spend a little time about that. And this is not the end all or be all. Of course, there are many other types of coverage and policies out there. This is just the ones that I see quite a bit. Um, the standard policy, for the auto accident, that's just a bodily injury or property damage policy. There, you of course you're paying particular attention to the policy limits. Um, the limits is the most important and limitation in coverage. It's something that the carrier probably needs to jealously guard to make sure it stays in place. It's the one that's been interpreted the most, and it will be upheld, assuming the carrier manages to keep it in force. Uh, and then, of course, you know, there are other exclusions. I raised the intentional acts exclusion because that's the one I'm most familiar with. In owners and landlords and tenants policies, we've got various limitations. They're not going to cover the return of rent. They don't cover, any kind of claim. No policy covers a claim for breach of contract. Um, it many times the owner's landlord's policy does not cover an attorney fee award. If the plaintiff were to recover attorney's fees, depending upon the breadth of that policy, the insured may be stuck, and the carrier may have no obligation whatsoever to pay any amount of fees that was awarded to to the plaintiff by the court. And then, of course, there are lots of well settled exclusions in those kinds of policies. Toxic substances, including mold and so forth, are typically upheld. So, there's lots of things that can happen in a policy that is not necessarily going to be covered. We see in employment, and I know Mike's going to talk about employment issues later on in the program. There, it's typical where you will have a large self-insured retention. That's what a SIR is. It's a self-insured retention. The carrier in the underwriting process has included incentives for the employer to make sure that their policies are effectuated and they don't end up with problem policies and so on. So they'll have the employer be responsible for the first 200,000, for example, or $250,000. What is a self-insured retention? Think of it like a deductible, but it's a deductible both for indemnity and defense costs. So if you have a self-insured retention, the insured is going to be on the hook to pay the attorney's fees up until that limit. It's typically a wasting limit. Once the insured has expended all of the money for whatever the SIR is, then the carrier has to pick it up. Um, and so you can see oftentimes they have wasting limits, even the carrier's portion. Let's say the policy is worth $1 million. Once the SIR has been exhausted and now the carrier is paying the attorney's fees and so forth, that also will reduce the amount that's left over for in the policy for indemnity. Again, we see the plaintiff's attorney fee awards. That's a huge one in employment cases. And most clients, I shouldn't say most, many employers have no clue. When I get into a mediation, they have no clue that because they haven't really been paying attention to it, that if there's an award by the court to the plaintiff for attorney's fees based on a statutory claim, they have to pay it. And the carrier doesn't even have to pay that because they didn't pay for that extra additional coverage. In employment cases, employment policies, you're sort of ordering off a menu. If you pay a higher premium, you can get coverage to cover you for the exposure for a plaintiff's fee award. But if you don't pay the premium, you don't get that coverage. And then, of course, we see consent clauses in employment uh, cases. Sometimes the employer doesn't want to settle, and they withhold consent. So you have to look at that. You see those same kinds of provisions in professional liability policies uh, that can complicate things, can complicate settlement. The physician refuses consent above the threshold level, and so on. So that's a key consideration. And then, lastly, that I have a thing there for construction defect cases. Here's one where, again, the contractors typically, unless they're a big contractor, then they do understand coverage and they have coverage counsel. But if you're talking about a small contractor who's got an S corp, typically they have no clue uh, that of what this policy will cover. And of course, here's what it doesn't cover. It doesn't cover anything related to breach of contract. It doesn't cover anything for the contractor's own defective work. That's not considered. That doesn't even trigger the coverage promise because the contractor's work and faulty work is not considered to be an accident. Even though the contractor may mistakenly do something, they didn't mean to misread the plans, etc. And you'll see that one of the hypotheticals we have later on. But they did misread the plans, or they misinterpreted the property line, and they built a foundation that encroaches on the next door neighbor's property line. The problem with that doesn't even get past the coverage grant because their work is not considered an accidental. They deliberately built the thing they built where they built it, etc. All right, so that's enough for that. Let's move on to the next slide. So we've already talked about it's really important that whether you're a plaintiff's counsel or defense counsel, if you have to plead your claims and your cross claims carefully with coverage issues in mind. If again for both a plaintiff and cross complainant, have you triggered a duty to defend based on the way that you've pled the case? Um, what does that do? If you've triggered the duty to defend, of course, that creates an incentive for the insurer to want to settle because even if they believe they have limitations on coverage, they don't want to have to defend the entire thing all the way through if they can avoid it. Of course, they're prepared to do it and they have the money to do it, but it is an economic decision. And without triggering coverage under the policy, then you're basically, if you're plans counsel, you're left to try to recoup assets from the insured, and they may be limited or very very limited. Um, it's important that you lead the thing properly, that you also consider have you identified all the funding sources? You know, when you look at the basic form interrogatory, the Judicial Council form interrogatory 4.1 and 4.2, it's a good start, but it's not enough. You can't just rely on that. You need to make sure that you tailor your discovery to get the information you need to get the reservation of rights letter. If you just use 4.1 and 4.2, they just have to tell you whether there is a reservation of rights. You still have to follow up and get a copy of that letter to really understand what the carrier is telling their insured are the limitations of its coverage. I think you can move on to the next slide, Katie. So, yeah, are there reservation of rights letters? And get them. You need to get them because their key resource, the carrier is obligated to tell their insured all of the bases upon which there's a limitation of coverage. They're not allowed to leave anything out. They always include language at the end saying, well, and we reserve the right to add additional limitations as they become known to us. But the truth is, if you have all the reservation of rights letters, you'll have a pretty good idea of what of sort of the outlines of the potential coverage limitations that you might have to face. And then, of course, are there are there any self-insured retentions? What are their limits and so forth? It's important for you to understand that, to understand how the interplay is going to be when you're trying to negotiate a settlement. Um, are there any pooling agencies involved? What is a pooling agency? A pooling agency is typically, you'll find it a great example is if you've got uh, a school district, and they're the defendant in a particular case, or some other kind of public agency that then wants to pool resources with other public agencies like it, utility companies and so forth. And so are there any pooling agencies involved? You're going to need to understand that so that you can make sure that everybody is put on notice and they'll be at the table later on if you're going to try to settle the case. Um, let's see if there's anything else. No, I think you can move on to the next. Thank you, Katie. So it's important. Obviously, insurance is super important for purposes of settlement and settlement negotiations as you go forward. Um, and whether you're a defense counsel or plaintiff's counsel, you really need to understand the interests of the insured, the defendant. You also need to understand the interests of the insurance company, even though you may ethically not be able to provide advice about that if you're retained counsel. You certainly need to understand the issues regarding coverage because even though you can't give your client advice about coverage, maybe you at least need to explain to them that they might be better served to get coverage counsel to be able to give them that advice. So it's important for you to understand that. Uh, so I include the thing, does your insured have coverage counsel? If so, great. Well, now you can rely on that. Or do they need coverage counsel? Like I say, lots of times in settlement conferences or mediations, the insured shows up, they don't have a clue. And they don't have a clue that there are serious limitations in terms of what types of indemnity that they could receive. Um, I think even mediators need to understand this stuff because they need to be able to pull the insured aside and at least answer any questions the insured has about the limitations when the carrier is saying, oh, no, well, we don't cover that. We don't cover this type of claim. We don't cover that type of claim. You're on your own when it comes to the attorney fee award, et cetera, et cetera. Um, insurance carriers expect the neutral mediator to understand the basics of coverage and be able to have separate private discussions with the insured to at least answer their questions about it. Um, and then I think it's important because there are opportunities to create synergy between the insured and the insurance company that actually helps get to a global settlement. We'll talk about that in more detail later. But in essence, carriers, just like with a self-insured retention, they want their insured, if there are limitations on coverage, to share the pain. And if an insured is prepared to share the pain, then guess what? The insurance company's more willing to step up and provide indemnity, even notwithstanding the existence of coverage issues. So it's super important for you to understand that. Let's see. So you can move to the next slide, Katie. So obviously, it's important to understand the coverage limits, to know the exclusions that are really key to the particular facts involved in the case, to understand, self-insured obligations and so forth. Understand the insurer motivations in settlement. We're going to have a nice explanation of what insurers are allowed to consider and not consider a little later on in the presentation. All of these facts or factors, I should say, are important to help you prepare your client for the mediation, whether it be a plaintiff or defendant. You need to be able to prepare them to understand what's really feasible in light of the potential limitations in coverage. The last slide, we had a discussion at the beginning of this when we were putting it together about what's a great resource for folks to start with, because insurance can seem overwhelming, and people's eyes glaze over. We're shunned at insurance. Coverage lawyers like me are shunned at cocktail parties because we enjoy this stuff, but everybody else will drive away if we start talking coverage. Trust me, people will want to talk to somebody else. The best resource, I think all of the lawyers here agree, best resource to start with is the Rudder Group Guide, the California Practice Guide on Insurance Litigation. It does an excellent job. It's kept current, etc., and I highly recommend it. That is the end of my overview. I will turn it back to Judge Grillo and to
Okay, thank you, Paul.
Cochran. Thank you.
A very good explanation of all the factors you must consider before you go into settlement. We're going to now turn it over to Joan Cochran, who's going to be talking about carrier considerations and what the carriers can consider when they are in settlement or when they are discussing settling a claim on behalf of the insured. And the entree to that is going to be a little poll that we're going to give you. Can we see the next slide? Okay, and the poll is, what do you think an insurer can consider when evaluating a settlement offer in a personal injury lawsuit? That's the question. You can see the alternatives over there, and this is just a simple multiple choice. Let's just take a minute to do that, and that'll help Joan with her presentation. This will give us an idea of our level of knowledge. We're going to get the results on that in just a minute.
I have launched the poll into the audience. Everybody, you should see a little pop-up on your screen. Go ahead and respond to that. We'll leave it open for maybe 10 seconds or so here. Right. Any final answers? Go ahead and put your poll in. 3, 2, 1. Excellent. I'm going to go ahead and share our results. It looks like the predominant answers are all of the above with 65%, followed by 1 and 2 with 24%. Over to you, Joan.
Okay.
Take it away.
Thank you. So yes, with that, thank you, Judge Grillo and Judge Herbert. It seems a little grim, I think, for some of you practitioners when you hear, well, the insurance company is going to require this, the insurance company is going to require this, and here's the parameters. But you may be surprised that when in a personal injury case, the insurer can only look at two things. If you go to the next slide, Katie, under the Johansson case, all that can be considered, and go one more to the next slide, are the issues of liability and damages. So limits imposed by the policy, a desire to reduce the amount of future settlements, or a belief that the policy does not provide coverage are simply issues that an insurance adjuster cannot look at all in a personal injury case. And it's surprising how on both the plaintiff's side and the defense side, how and the adjusters out there may not realize the importance of Johansson. And those two aspects are the only issues that can be decided. So you cannot look at exclusions. If you have to look at damages, if you have a personal injury accident and there's both intentional conduct and negligent conduct, but the damages are significant, you cannot try to adjudicate that when you're evaluating the settlement. You have to accept everything. You have to look at the issues of liability, and damages. So if you could go to the next slide. So as this quote, the only permissible consideration in evaluating the reasonableness of a settlement offer becomes whether, in light of the victim's injuries and the probable liability of the insured, the ultimate judgment is likely to exceed the amount of the settlement offer. So that's significant. And what we will see, if you go to the next slide, is that under Johansson is actually the foundation of all bad faith in California. It's been codified in the insurance regulations and the fair claims regulations, and it actually is now in the Casey jury instructions. with the newest case that's come out in terms of if an insurer does not take those two things into consideration and doesn't look at a reasonable settlement offer in light of liability and damages, that's when the insurer can be held in bad faith. So if you could go to the next slide, please. So then you must ask, well, can a refusal to settle be in bad faith if no exposure, if there's no excess judgment that you can be exposed to? Can the insurer, you think, Joan, well, is it the only time where there's this opportunity for an excess judgment? Is that the only time the insurer can be held in bad faith? So what do you think?
I have the poll launched in the audience here. If you have not done so yet, please go ahead and submit your answer. We'll give it another 5, 4, 3, 2, 1. Excellent. Our results here are 63% say yes and 37 say no. What's the answer, Joan?
The answer is yes. And if you go to the next slide, you will see that if an insurer is for example, if there's been a delay in paying a portion of a claim, or if it's just been unreasonably evaluated in terms of liability and damages. And what you'll find, and we have the codification, there's actually 7 factors to determine whether a settlement is low or a settlement is reasonable. And those are found in the Fair Claims regulations. And one of those is the defense counsel's evaluation of liability and damages. And it doesn't have to be a potential demand or a exposure in excess of the policy limits. It could be within the policy limits itself. So that's important to keep in mind. All right, next slide. And so now you say, well, Joan, if you have a personal injury case and you only can be looking at liability and damages, is there ever a time when you can look at other factors, like like Judge Herbert had said, what is covered, what is not covered, looking at the insurance policy? And this case is usually in a construction defect case. You have the Camelot case. So if you have a mixed action where there's really no dispute, or in a warranty of habitability case where there's really no dispute, like Judge Herbert said, where attorney's fees are just not covered, or in a construction defect case where the work of the subcontractor is just not covered, can you consider that when you're in mediation? What do you think? Yes or no?
We have the poll launched here. I'm going to give folks a few more seconds to respond, hoping to get up past the 50% mark. All right. Any final answers in 3, 2, 1. Okay. Our results are 68% says yes.
Okay, excellent. For those of you that said yes, you are correct. Camelot stands for the proposition that if there really isn't any dispute, it's not like a personal injury where, liability is disputed, whether it was a wrongful act by the insured. Here, if there's really no dispute and everyone is in agreement that certain things are simply not covered, there's no ambiguity in the policy. It's been litigated, the wording is proper, it's can't be construed in two reasonable ways, there's no ambiguity, then yes, you can. So keep that in mind for those types of cases, like warranty of habitability, construction defect, unlike usually your comprehensive general liability policy with property damage or personal injury, which is very different. So, but that's, very important to keep in mind when you are in a mediation and you're looking at those different policies.
Okay, I'm going to suggest we go straight to the next poll so that we have time for all our panelists to do their hypotheticals.
Yes.
And then we will move to some of the more specific subject areas. So let's do the next poll and then we'll do the explanation and then we'll move on.
So launch the poll, you mean, Judge Grillo, or just go through it?
Oh, yeah, let's do this poll right here. Did the insurer act in bad faith by failing to effect settlement
Yes.
in absence of a settlement
Yes.
demand when liability is clear?
Right. So, in other words, when liability is clear, does the insurer have a duty to effectuate settlement, to offer a settlement in absence of a settlement demand in California when liability is clear?
We'll take answers for 3, 2, 1. All right. And we got a 60% yes on this one.
Okay. So I will just quickly go through this. So this is the due case. If you go to the next slide. So at one time, the court did say that you did have a duty as an insurer to effectuate settlement, even in absence of a settlement demand, but that is no longer the case. So the Ninth Circuit came down and said, while it's a good practice, there's no duty to effectuate in absence of a settlement demand. But as you'll see later on, there are codifications with a section 998 that will be discussed that is requiring insurers, even before litigation starts, to evaluate in good faith settlement demands when there's a reasonable amount of information to do so.
Okay. You'll find in your materials published in the slides 7 factors to show if a settlement is low. That's citing a section from the insurance code. Why don't you take a look at that? You think you'll find that helpful. It's a lot of fodder to use when you're in a settlement conference. Tanya Goberman, what's new with policy limit demands?
Yeah, I'll be really quick on this one because CCP 999 is very specific. The insurance industry wanted to unify what's considered a reasonable policy limit demand, and really more importantly, what's not considered a reasonable policy limit demand, because you could follow all of this and still the court could consider it not reasonable. But there's very specific provisions. You have to say that it's a time limit demand. You have to give them at least 30 days. You have to give them enough information to determine liability and damages. And if you fail to do that, you won't be able to argue that the pre-litigation settlement at some point opened up the policy. That doesn't mean later on, if you serve a 998 or a second demand, you won't be able to argue that the policy is open. But with pre-litigation settlements, if you want it to be considered a reasonable settlement demand, you must follow all of the terms. And literally go into Google, ChatGPT.
We are getting some echo here.
Yeah, I got an echo too. But it will tell you all the factors. It will tell you what you're missing. There's a bunch of articles, but this is really good for both sides because there were people sending demands saying, hey, we demand your $2 million policy limits tomorrow. And that's obviously not enough time for the insurer to consider it.
Yeah. So the takeaway is, Tanya, those brusque letters with short fuses delivered just before a settlement conference or a trial are out now. Would that be a fair statement?
Yes. And really providing as much information to the insurance carrier as possible, like sending just the emergency room bill and saying, hey, give me your policy limit in 30 days is probably not going to be enough.
Okay, great. All right, we're going to move on now to the excess carrier problem. Many of you have probably been in settlement discussions or mediations where you have a claim that's more than the primary and there's an excess and the excess doesn't show up. We have a couple of hypotheticals for this. I think I'll do the first one and leave you to your own devices to read the other two in the interest of time. tortious transportation, a trucking company is insured by P Insurance under a non-wasting policy with $1 million bodily injury limit. The excess insurer has coverage of $4 million. And I'll let you read the whole thing, but the plaintiff's counsel, based on overall insurance coverage of $5 million, makes a policy limit demand of $5 million in advance of the mediation, complying with Section 999, with the expectation that the excess carrier will contribute to the settlement during the mediation. The excess carrier attends the mediation but refuses to contribute. Plaintiff's counsel declares that the plaintiff will sue the excess carrier for bad faith. Next slide, please. Here's the poll. How much insurance is available to satisfy McGillicuddy's claim?
We have launched our poll here. Everybody go ahead and put in your votes. We'll give you a few seconds to respond. We love to get at least 50% audience participation, and you've been doing great so far. So go ahead and put in your responses in 3, 2, 1. All right. Judge Grillo, I think you have a hung jury here. We've got 56% says 5 million and 44% says 1 million.
All right, let's go to the next slide. Okay, there's 1 million available because under California law, the primary has to be exhausted before the excess has any obligation at all, before the excess is triggered. In this case, the primary was neither exhausted nor offered to the plaintiff, and so the excess has no obligation to contribute. Now, I'm going to kind of skip over the next two polls in the interest of time. Let's go to the next slide. Okay, same facts, but the policy is interpled. Is that enough? Next slide. No, there's no constructive exhaustion exception. The policy actually has to be offered, so you can't get around that requirement by interpleading it, although it seems counterintuitive to me. That appears to be the law. Let's go to the next slide. Same facts, but the primary is paid the full amount of the policy, and there's no other primary policies that may provide coverage. This is, let me see the next poll. I think that's wrong. Yeah, there it is. Yes, that poll part was wrong on that one. The payment of the full amount of the primary triggers the excess for covered claims. Although excess don't have a duty to contribute to settlements, are until the primary is exhausted. Once it is, they have to contribute. So that's the rule on excess. For those of you who are wondering why you can't get that excess to participate, that's the reason. You got to get that policy, that primary exhausted. Just a little footnote, which I don't have in the materials. Many, in fact, a lot of excess policies require the primary to advance the defense costs to the excess. So not only is there a hesitancy or a refusal of the excess to contribute before it's exhausted, but a lot of times they don't have a dog in that insurance defense fight because the primary is paying all of it. All right, let's go to the next topic area. I think this is Tanya Goberman, who's going to talk to you a little bit about how carriers, and I guess us mediators and you should be looking at various scenarios of coverage. Tanya?
All right. So personal injury case, we're going to kind of get a sense of how much people know. The fact pattern is little Johnny, who's 10, is hit by a car while riding his bike. His medical bills are $1 million, clearly high value case. He lives with mom, dad, and grandpa. And let's see the fact pattern, the first hypothetical. So I guess we can talk about the governing rules real quick. So uninsured motorist caps, you have to look at the policy pretty much for everything in personal injury and probably everything else. You have to look at the policy. I've seen all kinds of exclusions. But there's no stacking in California. That's really important. pro rata allocation, really, it doesn't matter. You look at the highest amount, and if the insurance companies want to split that because multiple policies apply, that's kind of between them. Household members in most policies are considered insured and are also considered excluded. So one household member can't make a claim against another household member, and intentional acts are excluded. So now we can go to the question. So in that hypothetical, if the driver has 25,000 in liability insurance, mom and dad have 250 in uninsured motorist, and grandpa has 100, 300 in uninsured motorist, what is the maximum that little Johnny can recover?
All right, we have the poll in the audience here. This one's getting a little bit trickier than yes, no, going multiple choice on us. Everybody get your answers. We'll give it 5, 4, 3, 2, 1. Okay. And the one with the most responses is the 250K.
All right, and that is the correct answer. So we can go to the next slide.
Oops, sorry, lost my screen share there. Give me just a second.
So there's no stacking. I think that's the biggest issue. And the second number, so whenever you see policy limits and it says 1530 or 2550, that just means how much per person and how much per accident. So if only one person is injured, don't even look at the second number. But if you have 5 people that are injured and it's a 250-500 policy, that 500,000 is the maximum for all 5, but no one person can get more than 250. This is just how it's calculated. Really, for the plaintiff's lawyer, what matters is the total recovery, and that's 250. Which insurance pays it and how they share is a little less relevant. All right, personal injury scenario 2 is pretty much the same thing, but it's reversed. Grandpa has 250, mom and dad have 100, 300, and we can go to the next slide. The result is the same. Again, the insurance company, the maximum is 250. The insurance companies just split the pro rata share because he lives with both of them, so they're both uninsured motorist applies from both coverages. Personal injury case 3, the driver has a $1 million liability policy and mom and dad have the same policies. So what's the maximum that Johnny can recover? Next slide. That's $1 million. So there's no uninsured motorist underinsured because you can't stack the policies. And this is really important because if you have a policy from a different state and an accident in a different state, such as some states do allow stacking, in which case you can get the maximum from every single insurance company that provides insurance.
Quick question on that, Tanya. When you say some states have stacking, whether or not you can stack a policy would be based on what state you're in, where the action's brought, or the language of the policy?
Yeah, I think it's where the accident happened in most situations, unless the policy states something different. Because I've had a lot of accidents that happened in California where the policy was from Texas, and I think it would be very hard to argue that you could stack.
Okay, thank you.
Scenario 4, same situation. What's the maximum that Johnny can recover if the owners only have 15,000, or the driver's uninsured, the owner of the car has 15, and mom and dad and grandpa have the same. And again, it's 250,000. You still have to get that 15,000 from the owner of the car because that's still liability and for third party coverage. All right, we can go to the next one. These are going to get very interesting. Okay, let's say the dad was the driver that accidentally hit Johnny? So dad accidentally hit Johnny, and dad is named on the insurance policy for liability. So can Johnny recover from dad's insurance up to the policy limits?
This is launched as a true false, so true would indicate that yes, he can recover. False would indicate no, he cannot. We'll give people 3, 2, 1. And ooh, Tanya, you've got a tricky one here. We're at 51% true, 49 false.
All right, let's go to the next slide. So Johnny cannot recover because he's considered a household member under most policies. Again, you have to read the language, but one person who is covered under the policy cannot recover against another person who's also covered under the policy. Number 6, let's say Johnny only lives with mom because his parents are divorced, and dad has 100, mom has 250, 500. Dad is the one that hits Johnny accidentally. Let's see what the answer is to that. So the maximum is 250. He can recover against dad because dad is no longer under this, or Johnny is no longer a resident under dad's policy. And under mom's UIM policy, he can recover because he is a resident and that insurance applies to him. Okay, next one. And this one I actually, the slide is a little wrong. So if he lives 50-50 with both parents, you have to look at a whole bunch of factors, but usually he's considered a resident of both households and cannot recover under either policy. So this one is right that he'd be a resident of both households, but it's wrong in the total recovery because most of the time that would be 0. But if it's like you get into a lot of really specific issues like, well, does he have a bedroom at dad's house? Does he keep his clothing there? Is his visits regular or does he just come occasionally? So it's a rare situation, but you have to look at the language of the policy and the case law. All right, we can go to the next one. So what if dad hits Johnny and mom while they're crossing the street? They're still divorced. And dad has a $1 million liability policy. So who can recover and how much? So both claimants, mom and Johnny, can recover. And here, if it's a single limit case and there's only $1 million, they must share the total $1 million policy. All right, let's go to the next one. Is there a conflict of interest? I know we're not doing an ethics panel, but this is something we should always be thinking as personal injury attorneys, because there are a lot of single limit policies. So there is a conflict of interest between mom and Johnny is true. If you disagree with that, then it's false.
Great. We have a pretty definitive answer here, so I'm going to wrap up our poll. The people speak and they say true. There is a conflict of interest.
Yes, there is a conflict of interest because they have to share the same amount of money. And with kids, you also have to do a minor's compromise. So I'm sure Judge Grillo has looked at these a lot. In Alameda County, they really, really look at minor's compromises. And most of the time, the attorney a lot of times wants to allocate more money to mom because mom gets the money right away and because mom will probably pay 1/3 in attorney fees, whereas the child will pay 25%. So judges really look at that. They will not sign off on a settlement where the kid is getting a very small portion, especially if there's serious injuries. And really, one attorney should not be representing both. Next. Number 9, what if dad is driving his work truck? Work has $5 million policy. Here you look at several things. Is he in the course and scope of employment? And I think if it's a work truck, you have a very good argument that it applies even if he's not. But we can go to the next one. And the maximum that he would recover is 6 million. You actually get to add the excess policy or the employer's policy, sorry, on top of the first policy. So it's not 5 million, it's 6 million. And I think this is our final scenario. What if dad intentionally runs over Johnny and mom because of jealousy? He's driving his employer's car. How much can Johnny recover?
Yes, this is our final poll in the personal injury section, and if I may say so, the spiciest. So let's see what the people have to say. We will give you 5, 4, 3, 2, 1. All right. And the people say 58% say none of the above, D.
And that is correct. Unless you can show the employer had some type of negligence, like let's say he came to work drunk and the supervisor saw he was drunk and still gave him the keys, you might have some other type of independent negligence claim, but otherwise intentional acts are not covered. They can sue dad personally. That would be an interesting lawsuit.
Okay, we are now, thank you very much, Tony. That was very informative. It kind of makes us look back to one of Paul's original points, Judge Herbert's original points about find out what policies you have and look at what they say before you start figuring out what you're going to get. Okay, we're now going to have our Tales from the Crypt moments in this presentation. These are actual stories and actual scenarios that Judge Herbert and Mike Lorenzen have experienced, and they're going to talk a little bit about how insurance coverage impacted the settlements on these cases. We have a poll here to start out, and it says how many of you practice employment law or have experience with EPLI. And that's, I'm glad you wrote it in there, Mike, employment practice liability insurance, because I didn't know what that was. Let's answer that poll, and then we'll turn it over to Mike Lorenzen.
Great. Thank you, everybody, for responding. It looks like we have about 60% of our audience who has not had experience with employment law or EPLI, and about 40% who have. So you'll have some educating to do, some great minds interested in hearing from you, Mike.
Thanks, Judge Grillo and Katie. I designed some hypos to get to an issue that is common in EPLI cases. And, Tanya observed earlier, or when we were planning this, that, sometimes in her cases, she doesn't even interact with or care about the insured. It's all about the insurance. And an employment practices liability insurance claim is a lot different than that. And it can really vary based on the circumstances, who has a greater say in the negotiations and who you have to pay attention to. So this will give you a little insight into what's going on in the defense room in your EPLI mediation. So here is our fact pattern, pretty common fact pattern. Jane Smith is a former employee of Silicon Valley tech unicorn. Isn't AI great? By the way, a unicorn is a company that's hit $1 billion in valuation. She was employed as the executive assistant, or EA, to the company's current CEO, Jack Ryan. She has filed suit against Isn't AI Great and Ryan in state court, alleging that she was sexually harassed by Ryan during her employment. Ryan had a similar claim made against him by his prior EA, but it was settled out of court. Isn't AI Great has EPL insurance with ABC Insurance. The policy is a wasting policy and has a $250,000 deductible self-insured retention. They're synonymous in my world, and $1 million limit. And so let's see how those things play out under a couple different scenarios. Slide to scenario 1. So ABC would like to settle the case, the insurance company, due to the potential exposure posed by the serious allegations and believes the case is worth $500,000. But the company, the insured, isn't AI great, is standing behind its current CEO and, quote, doesn't want to pay her a dime, unquote. What happens in that situation? Well, it is not uncommon for me to have this situation at a mediation. And because of the fact of the $250,000 deductible, if this is an early mediation and that deductible has not been satisfied, that insured is driving the bus until that deductible is satisfied. And the insurance company cannot settle that case, no matter how much they might want to. And I've actually had cases before go to trial because a deductible has not been satisfied, even at the courthouse steps, because the case was perhaps slightly litigated. And the insurance company, while they would have been more than happy to pay a nominal settlement, they're not able to because the deductible hasn't been satisfied yet. The self-insured retention hasn't been satisfied yet, and the insured has managed to compel that case to go to trial. Judge Grillo, you have any observations here? Have you confronted this scenario in your mediations?
It's the reason I don't have any more hair, because I would confront it and I would pull all my hair out. So yeah, I've seen this one a lot.
Yeah. So in that case, you might have an adjuster willing to be reasonable and willing to settle the case. But if you have an unreasonable insured, that case is not going to settle.
Mike, I have a question.
Yeah.
Sorry. On that, what happens when there's
a provision in the policy that says that settlement authority cannot be unreasonably withheld, and let's say that the exposure of the case is well over 250,000?
in that case?
Yeah.
would-
If there is such a provision, there could be a fight there. I mean, there's going to be a fight about valuation in that situation. You're still going to have to get a demand that's under that. So, but if there's such a provision, that could cause such a dispute. But I have, in the situations that I've confronted this, I've never had an adjuster be able to compel an insured to settle under those circumstances. I've never seen it.
Yeah, because there is case law that usually you have a provision in a professional liability policy that will say the authority cannot be unreasonably withheld if there's a consent clause.
And if and usually from the point of view of the insurance company, you would, as coverage counsel, I write a letter saying that you cannot,
If you do withhold it unreasonably, then you have to end up settling the case at your expense. That's how the
I
insurance.
think the kicker is the self-insured retention. In other words, I don't believe an insurer can compel an insured to exhaust their self-insured retention. That's their money. So I think it's a different scenario if the SIR has been exhausted. I think that's when it comes into play about not unreasonably withholding settlement authority. But I don't think you can compel an insured to exhaust their deductible like that.
Okay, let's do another one.
Okay, next scenario.
Let's leave a little space for the construction part of it too. Let's take a look at another situation.
Okay, so in scenario 2, Smith, the plaintiff, has made a $750,000 demand. And in this situation, the company, isn't AI great, has demanded that ABC pay it due to the potential damage the claim could do to the company as it approaches its next funding round, and is willing to contribute its deductible toward the settlement. But ABC doesn't believe the case is worth that much. That is where you're going to get into the scenario about whether it's reasonable for the insurance company to pay that demand, whether the case is worth that. I think in this scenario, you're not going to be able, and the insured is not going to be able to twist their arm into paying it if they don't view that the case is worth that, because appropriate things have not been triggered and there's a dispute about valuation. In other words, this is an insured that just wants to make this go away for business reasons. And I don't think in that situation, they're able to compel the insurance company to resolve it.
And what's the
Okay.
next hypo? What's the next hypo, Mike?
Well, I think this changes scenario two. In scenario three, everything's the same except this time it's a policy limits demand, and I think that changes the dynamic a bit. Certainly, there's the rules for pre-litigation policy demands that Tanya talked about, but even once we're in litigation, if you have a policy limit demand and you're looking at potentially being on the hook for the entire judgment, I think this might engender some more willingness on the part of the insurance company to resolve the claim. And the final scenario, scenario four, in this case, the plaintiff has made a demand of $5 million due to the potential for punitive damages based on the fact that the board of Isn't AI Great was aware of the prior claim by the prior EA, but did nothing about Ryan's behavior. So this is a situation we face commonly in employment claims when there's genuine exposure to punitive damages, which of course aren't covered. So here, in order to settle that case, once the insured has put up its, once the insurance company has put up its policy, that case is only going to settle if the insured is willing to make a significant contribution towards the resolution, because the exposure is based on punitive damages, which aren't covered. So this is a situation that's very common in employment claims and would require some kind of contribution by the insured above its self-insured deductible. Okay, and I think we can skip the last one, scenario 5, so we can get a couple of construction hypos. And 6.
Okay, we're going to go to construction. Answer the poll, please, in terms of your involvement in construction litigation. I will confess to and apologize to Michael. I didn't lose my hair over employment cases. I really lost it over construction cases. That's where the hair came out. Let's take the poll.
Great, and this is our final poll of the program. So if you haven't participated yet, this is an easy low-hanging branch to hit. All right, we are getting some good responses here. I'll go ahead and close it in 3, 2, 1. And at a very satisfying 50-50 result here.
Wow.
Take that as you will, Judge Herbert.
All right, great. So let's just go right into the hypo. So here, we see this a lot in a construction case. Essentially, we've got a general contractor, small player. This isn't, this isn't a large general contractor. Small player holds limited assets of its own. He basically owns his own home that has a mortgage on it. He's got a couple $100,000 in assets if called upon. What happened here, of course, was that the nice family has a modest house in the Richmond district, 1,370 square feet. They'd like to put a second floor on the house. So they go ahead and enter into two different contracts with this particular small contractor. One is just to demolish and redo their kitchen. And then a second contract, which is to do the big remodel, including add a second story, reconfigure the first floor, etc., and turn this thing into a real lovely, livable, modern structure. Two different contracts. The guy goes ahead and gets permits, or tries to get permits for each of them. Of course, the kitchen remodel permit gets approved way before the overall remodel permit comes in. General hires sub to come in and demolish just the kitchen because that's what he's got the permits to go ahead with while the other one is in review. But unfortunately, uh, sub speaks a different dialect of the same language that General speaks, and he misunderstands his instructions, and he demolishes the entire house effectively, except for the facade. Basically, there's nothing much left of the house other than the basement. The basement is intact, and there's he's got the front door and some stuff on the side to kind of hold it up together. Uh, uh, Planning department in San Francisco immediately comes out and puts a red tag on it. They apply, and this is really true. This is really exists in San Francisco. The 5-year moratorium on any further permit reviews for the project. So they're not even going to because of course the family could always say it was an accident, right? I mean, that's what they're preventing. They're trying to prevent the planning department. So for 5 years, this family is forced to sue and do whatever they can do, but they've got to make payments on the mortgage and try to do the best they can. They go ahead and sue General and Sub, and the policy from Nationwide has a $2 million limit. So we go on to the next slide. So this guy's got limited assets. I told you he had limited assets. He's 43 years old, the contractor. This is what he does. He's a contractor. He doesn't know how to do anything else. He wants to be able to continue on in business for, well into his 60s. He feels terrible about what happened, but he believes his CGL policy is going to protect him because after all, the house was demolished as a result of an honest misunderstanding between himself and his subcontractor. So it's not an intention. Nobody intended to do this. This was an accident, Your Honor, and yada, yada, yada. So he expects Nationwide to cover him. Nationwide, of course, accepts the tender of defense, but with a very long and very detailed reservation of rights letter. And then, of course, General and Sub, because they have limited assets, they're really small players in the construction industry. When at the settlement conference there, they come in and saying, well, we're gonna declare bankruptcy. We don't have that much, yada yada yada. We don't have any money to offer. The poor nice family has been out. First, they had to rent another house, and then buy another house the entire time while they're also making payments on the first house. So it's an absolute disaster, right? So what issues and interests come into play to reach a global settlement? We don't have time for polls on this one. So, obviously the small corporations have insufficient assets to compensate nice family. And we see this a lot, right? The insurance carrier has strong defenses here to indemnity, but it still has a duty to defend because there's going to be allegations of resulting property damage. So the thing to keep in mind that's the most important coverage defense from the carrier's perspective is that this was not accidental conduct. I mean, yes, there was a misunderstanding, but this wasn't accidental conduct. And so the question is, does it even come within the coverage promise? Now, in this instance, the carrier Nationwide, they don't want to get sued for bad faith. They go ahead and offer a defense, but they issue a very long reservation of rights letter. And of course, and then what are the interests of nice family? They just have enormous damages, but they have no sure opportunity to recover because there are significant coverage defenses from the carrier, and the contractors are relatively, certainly don't have the kind of assets they're going to be able to rebuild these people's house. So you have to ask yourself, well, how do you just give up? I mean, what do you do in this situation? What interests can you work with? What are the real interests that everybody still has, notwithstanding what I just shared with you, the disaster I just shared with you? What interests do they really have? And so you have to ask, for example, let's take it one at a time. For the general and the subcontractor, who are small players, is it really in their best interest to declare bankruptcy? Is that really going to get them out and it can allow this man to continue to operate in the construction industry for the next 20 years? I would argue the answer to that is no, it is not. It's not in his best interest. If he declares bankruptcy, now he has to hire two. Essentially, he has to pay two more lawyers. The carrier is not going to pay them. He's got to pay his bankruptcy counsel, and he's also got to pay the bankruptcy trustee, who will have every control over every asset of course, he has to list the assets on his schedule of assets. Otherwise, they're not protected. So he has to list everything. And now the bankruptcy trustee has control over all those assets. And as we all know, we all should have gone into bankruptcy law because the bankruptcy trustees they have the highest hourly rates of any lawyers I've ever seen. Or $1,000 an hour is I would say is standard. So so maybe bankruptcy isn't the right way to go. In addition, the problem from the contractor's point of view is, okay, well, he says, well, I'm going to declare bankruptcy. I'll form another S corp. It'll have a different name. I'll be fine. I'll be able to continue on in business. What's the problem with that scenario? Here, what of course, the plaintiff's counsel has been smart enough to do very careful pleading to make sure they include the alter ego theory, and they're going to pierce the corporate veil and so forth. And of course, what you find in situations like this is the big companies, they have adequate capitalization. They follow all the formalities. Small companies are terrible at that, and they don't have adequate assets and so forth. And the notion of piercing the corporate veil, that's an equitable claim that is tried to the judge, not to a jury. And the smart judge tries that issue first, because the smart judge will realize, if depending upon the outcome of that limited issue, the case might settle. Once the general contractor understands that his personal assets are at risk, maybe he has more incentive to actually help get the case resolved. What about the insurance carrier? What are their interests? Well, while they have all these great coverage defenses, they don't have any great exit strategy. They have an unavoidable duty to defend that's going to go on throughout this case. They're going to take this guy to trial. He's going to get hammered. The contractor, the one thing we can say with certainty is the contractor and the subcontractor are going to get hammered at trial. So the carrier's got to defend that whole thing. Then, of course, once he gets hammered, the plaintiff's counsel is likely going to ask for an assignment of rights to go back and sue the carrier, right, to try to recover. So now the carrier's got to defend a bad faith action. So now that we've got a second lawsuit. So now the carrier's got lots of incentives to try to financial incentives to try to get the thing resolved. And of course, the last thing is you say, well, okay, what ultimately really happens in the jury verdict? The carrier has to understand that the jury verdict form, proposed by retained defense counsel, cannot segregate the different types of damage between, damage that was caused from the demolition versus resulting property damage. And in this scenario, of course, there was some resulting property damage. There was damage to the basement, leakage coming through, and so forth. So they can't segregate that, because on the jury verdict form into what was covered and uncovered, they're just going to get a jury verdict, a special verdict that shows the amount of the damage. And so, there's really no great option. If they were to try to segregate that, retained defense counsel, of course, that's going to raise a Kumis problem. And now all of a sudden, the carrier's got to pay a Kumis lawyer to come in and supervise to make sure that the jury verdict form doesn't do anything that harms the insured's coverage position. So what can you do? And I'll keep it brief. What can you do? You provide incentive for the insureds to share in, maybe they can't do everything, but the guy wants to continue on in business. Maybe he can make payments. That you want to try to create some synergy between the insured and the carrier, so that maybe he can make monthly payments, and it's within his best interest to do that, to forestall the actual entry of a judgment. And so he makes payments. That in turn creates a synergy with the carrier. Now the carrier feels more likely and more willing to offer up money because, of course, it has an economic interest in resolving the matter. And then lastly, of course, we've got the insureds. I mean, not the insureds, the plaintiffs, the Nice family. They need to be taken from wherever they are in the litigation to the end game without having to incur more costs of trial. And how can you do that? You can do that by providing you know a, a payment schedule for the contractors, that if they fail to make payments and they go into default now, the plaintiffs can go and get a default judgment entered against them. Basically, take them to the same place they're going to be anyway, because this guy's going to get hammered at trial no matter what. Take them to the same place without having to incur those costs. So you can kind of work all of that. And the coverage issues are super important to everybody, but there is a way to solve problems even of this dimension. I will stop there and turn it back to our.
Well, I would just offer one observation, Paul. It seems to me what you're saying is the carrot of insured participation helps the carrier avoid the stick of a potential assignment and on a bad faith action and results in money flowing to settlement.
Absolutely. Everybody has an interest in
Great.
coming up with a global.
Judge, just one other quick question. Don't you think also if there would be an early mediation and you ask the defense lawyer who's defending the contractor how much the budget would be to defend all the way through trial, and that then the insurer is going to have more incentive early on instead of going through all that to maybe agree to an early settlement?
Absolutely. Absolutely. And we're seeing that more often. I'm seeing that more often. People are assessing, especially in cases like this where the liability is really clear, that it makes more sense to come to mediation sooner rather than later. Do some exchange of information, a la, akin to Federal Rule 26, so forth, and get everything on the table and come to an early mediation. Absolutely.
And I just want to add that, the mediators talk about getting insurance and the defendant in alignment. A lot of times on the plaintiff side, we want the complete opposite. We want the defendant to think that their personal assets are at risk, that they're fighting with their insurance company to settle, especially in personal injury cases where the insurance company has 100% of the decision-making power. So a lot of times it's not in your best interest to make them aligned. And even in employment cases, a lot of times we want to create that conflict, because if the client just wants to make it go away because they paid their deductible, but the insurance company is not being reasonable, but the company is, let's say, Apple, and they have unlimited funds, but only a $1 million policy, for example, I think it would be in the plaintiff's best interest to create that conflict and have Apple push their insurance to settle.
Yeah, I mean, yes, they're all different kinds of variations, and it's really makes it fascinating, frankly, to try to work these cases and get them resolved. And but the insurance issues come into play big time.
Yeah, just intentionally choosing whether you want to create that conflict or create that alignment, I think is important. Not like whatever you do, if it's above policy limits, it can either hinder settlement or further it.
Yeah, but here, of course, in this scenario, the family, they're desperate, right? I mean, how many different payments can they make? They've got to live. They've got, they're absolutely desperate to try to get a resolution to let them move forward. And so now they can perhaps sell the first house.
And we will go into all of those and more in part 2 of this seminar, because from our audience participation surveys and from the intellectual content that our panelists have raised, I think we're going to do this again. Katie?
Thank you. Thank you, Judge Grillo. Thank you so much to each of our speakers. I think that was really fantastic, and you got to some great issues that many of our attendees, aren't familiar with, judging from what their backgrounds are here. So we are at our 1.5 hour mark here. We do have some great questions in the Q&A. So if you don't mind sticking around a couple of minutes, I'll pitch some of those to you. But if anybody has to head out, any attendees have to head out, you do get your full CLE credit. As a reminder, I will send out the CLE certificates via email within the next week, realistically this week. Take a look in your spam filter if you don't see them, and go ahead and reach out to us here at ADR Services if you don't see a copy. As you leave the webinar, you will be directed to a short survey. We really appreciate if you take a couple of minutes to fill that out. Let us know how we did, and especially any thoughts for future programs you would be interested in seeing aside from part 2 here. We do read those surveys and always take into consideration what you're interested in hearing about from our speakers. And as one final plug, if you still need CLE credits before the reporting deadline, which is going to be March 30th next year, please sign up for our big MCLE Day event. It will be on March 3rd and 4th, featuring 2 full days of CLE programming covering the full set of special credits. So that's the legal ethics, the elimination of bias, the competence, and those new ones, technology, civility, and wellness. All free, as all of our in-house programs are. Go on over to the ADR Services website on our CLE page to find the registration for that event. So without too much further ado, I see many folks are sticking around for some of these anticipated questions. So looking at some of these, I see some kind of early questions, probably when Judge Herbert was speaking. But do you have any suggestions on how best to draft a complaint so as to trigger coverage before the plaintiff's attorney has been able to get the relevant policy, since you can't get the policy until discovery sometimes?
Yeah, well, you're going to have to look, obviously plaintiffs' counsel are really good at collaborating with one another, and, uh, in terms of educating one another. There's a huge network, and you're going to want to talk to folks, I think, that have led, similar types of claims, to understand what sorts of, negligent hiring, negligent supervision, straight negligence. What can you do to make sure that you don't shoot your own client in the foot, so to speak, with regard to the insurance coverage issues? There are resources out there.
Yeah, I think negligence is always a safe bet. And not only is it a safe bet on the coverage, but if you hold back the intentional tort hammer, you can always amend later on if the facts in the case suggest that there's an intentional tort there and you found out that there are assets over and above what the carrier has. So negligence is always a safe bet in my view.
Here we have one for Mike from one of your employment scenarios. So Mike, in employment scenario number 1, can the carrier tell the insured that they're being unreasonable, and if they refuse to submit the 250, they will consider that as harmful to the carrier and they will refuse coverage?
That's a good question. I think it would depend on the language of the policy. I don't think it's something that they could obviously just do because they wanted to. So I think this goes to Joan's question and what the policy says. I still believe there's a problem, though, with the issue of compelling someone to. I mean, it's one thing to deny an insurance company, unreasonably deny an insurance company its right to settle a case it wants to settle. That's one thing. It's another thing to compel a company to spend its deductible. I don't know that you can do that, no matter what your policy says.
No, it's very interesting because I think if you had an exposure of, let's say, $1 million, and the defense counsel is saying, yeah, you've got an exposure, and it isn't intentional conduct, it's negligence, it's just the for all the wrongful issues that existed. I don't know if it's been litigated. It's a very interesting issue because I don't think it would be reasonable for the company to say it's not going to hand over the 250 if, let's say, it's a $5 million policy and exposure is, beyond even that. So, obviously, you're right. It depends on the policy wording And also, how much exposure is there above
Right,
this
right.
self-insured?
Is there agreement on the exposure or is it disputed?
Right, right. Yeah.
The one other suggestion I would have is, again, that's one where I want to find out from the insured, uh, does their policy include the additional payments coverage for the fees or not? Or is that an absolutely for a fee award to the plaintiffs? Or is that going to be an uncovered claim? Because if it turns out that there isn't, they didn't buy that part of that coverage. Now the insured has to understand, okay, I'm going to drag them all the way through trial. We know the meter's spinning wildly. The plaintiff's statutory fee demand is going to be enormous, many hundreds of thousands of dollars, and the company's going to be stuck for that. The carrier doesn't have to pay it at all. That can sometimes loosen the consent, the willingness to provide consent to the on the part of the
Well,
employer.
if there is a consent clause, and don't quote me on this, and I haven't seen any case law on it, but my analysis would be if I'm representing the company and there's a $500,000 demand from the plaintiff, and I'm thinking that the case is worth perhaps more, and I have an uncooperative client, and there's a consent clause, I might just pay off the $500,000 and then try to recover from the client the self-insured retention that they wouldn't consent to. That's a possibility.
It's not a bad idea.
Yeah. It's very
We have
good.
one. We have a question for Tanya here. A CGL policy has a 1 million per occurrence limited liability with an aggregate of 2 million and a product's completed operations limit of 2 mil. What limit applies to a personal injury arising out of completed operations? Is it 1 or 2 million there?
Yeah, I wasn't sure what that meant. Maybe it's a product liability case. So I
Mm,
don't know if somebody else can take it. I've never seen those like types of policies in my practice.
If it's a CGL policy that could potentially involve construction or any kind of that sort of thing, that's where completed operations endorsements come into play. And the on the one hand, the work performed by the contractor while they're actually on the job and before the job is finished is not covered. But if they finish the job and it's a completed operation and now they leave, and then there's a problem that causes resulting damage, not to the work itself, but to other aspects of the property, that's when that limit can come into play. And Joan may have other
Oh, I have more information here. The question asker clarified it's a food poisoning case, so the food is the completed product.
Interesting.
I see. So if multiple people are injured by defective food, which limit applies? I would say the per person limit would apply. So if one person dies, another 50 people are just puking for a week. I would say the person that dies would get the $1 million and the second million would be split between all of the people. But I think it becomes very difficult, and we have that in other personal injury cases. There's a 5-car pileup, and they won't pay for anybody's property damage because one person refuses to submit a claim. So there's a lot of those issues whenever there's more than one claimant, and you have either a single limit policy or an aggregate that requires every single claim to be paid from the total.
Mm, interesting. Okay, Judge Herbert, to your construction scenario, should a claim for negligent supervision be asserted against the general, and how would that affect coverage?
Well, it may, again, you have to really get the policy. Policies are getting more and more sophisticated, as different losses occur. So, for example, in the case of the Nice family, uh, the policy was, of more recent vintage in terms of its wording, and it also covered the operations of the sub and so on and so forth. So you really have to get the policy itself and look at it carefully to assess, what the limitations might be. um, doesn't really affect that much the carrier's interest because they still have this ongoing duty to defend that they just cannot shake, and they don't really have a good exit strategy to get out and to have unless they do a declaratory relief action and get a determination. But I don't see that happening as much as it used to. So yeah, it depends. You have to get the policy.
Mhm.
Yeah, and I feel like you can't always get the policy from your own client because
Right.
I've gotten the policy from a defendant before, and then when I contacted the insurance, like, oh, here's a document that says the policy will not cover any animal negligence, including fish. And it was like, what? Like the most random thing when the actual policy that I've seen says animal bites are covered. But anyways, I feel like you have to get the policy from the insured or have your client get the entire policy from the insured.
And
And
sometimes you need to go to the broker to get all the other policies on the risk. I just had one recently where there's only 6 months. This particular carrier that responded, and that is providing a defense is only on the risk for 6 months, and the construction project went over years.
Yeah,
And so, yeah,
I'll go way back to when I was a settlement judge in Alameda County, and we actually had a case where there was a broker, there was an insured, and there was an insurer. And guess what? A copy of the policies that they all produced were different. One had exclusions, client hadn't gotten so, and this is the broker what the broker thought he sold. And so, a little homework is in order.
yeah, you might have to
And
issue a
on
subpoena
that,
to the broker.
Mhm. I hate to cut you off, but we are about 10 minutes over. So I do want to respect everybody's afternoon and most especially your time as our speakers. I think we're ready to wrap up unless you see any burning questions in
can I
the
just say
Q&A
one
that you
thing?
wanted to respond. Go ahead,
This
Tanya.
is what I learned from Mike during our prep, that there was a $1 million sanction against a law firm for not disclosing
Excess,
An
excess.
excess.
not finding out about and disclosing an excess policy.
So I think as we're talking about this and like plaintiffs' lawyers should do XYZ or insured should do XYZ, well, really attorneys, especially defense attorneys, must find out and be honest about policies. Because I've had many cases where they're like, oh, we just found a $10 million umbrella. And it's like, I believe that in a lot of cases, the client or whatever the defendant is not being honest. But I also think in a lot of cases, the attorneys are just not looking because the excess policy is with a different insurance company.
Yeah.
And I'll put a period on that. When I was a judge, if I had a sanctions motion come before me where it involved not disclosing a insurance policy, my only question was, how much are you asking for? Because there's absolutely no excuse for that.
Well, and you can unwind the settlement, obviously.
Yeah, but how do you find out? Like we have this discussion all the time, and I have friends who will file every single case because like the insurance companies lie. And until you get into litigation, you only find out policy limits from that one insurance company, right? So yeah, it's a tough one because
You can,
pre-litigation, you might never find out what the full limits are if they have five different insurance companies with different
Well, and I'll
So
be honest with you, it's particularly weird if you're like me and you've been hired by the primary insurance. You're not even like the insured's regular attorney on normal matters. You're just been hired on that primary policy. So, but now all of a sudden I'm obliged to find all the other policies. It's a unusual situation.
So if you have the one
it's
policy, you can look at the whole policy and look at who brokered the policy because there
right,
usually is a broker. And now you have another place that you can go, but of course you're going to have to do it by subpoena,
right.
to make sure. So there's more, just form interrogatory 4.1 and 4.2 does not cut it. There has to be follow-up discovery that's done if you really want to, turn those rocks over.
And
Right.
what I just do is I send the defense attorney an email like, hey, did you hear about this case where a defense firm got sanctioned $1 million?
I'm sorry that I armed you with that, Tanya.
All right.
And now we
Well,
have our whole
this
topic
goes
area
to
for part
show that
two.
synergy is great, and I'm going to defer to Katie, and we will close it out. But I am looking forward with anticipation to our next one, and we will do another one.
Wonderful. Thank you once again for all of your time and for sharing all of your expertise
Thanks.
and for arming
Bye-bye.
the other side, everybody. And thank you, everybody who stayed on and listened to our last little tidbits. There were some buried nuggets there, some gems. So have a wonderful afternoon, everybody. We look forward to seeing you on our next CLE program. Happy holidays, everybody.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.